Good afternoon and good morning, depending on what part of the country you're in today. Welcome to our first webinar for the month of October. And we have Joe Nagy today presenting a webinar on trust. Before we get started on that, I have an apology to make. I sent out this morning instructions on continuing education. I noticed I did an error on it. I meant to give information on CFPs getting continuing education, and what I did is I just copied the instructions for CEPs. So again, I'm going to be sending a new one out on that, and I do apologize for the confusion on that. Also this morning we sent out copies of Joe's presentation ahead of time, so you can follow along either on your screen or from the printout of the slides that we sent you. This is going to qualify, as I said before, for continuing education for CFPs. Again, you'll email me your certificate number or the last 4 digits of your Social Security number, and we will report this directly to the CFP board. It's also going to qualify for continuing education for CEPs. And again, if you can email me your certificate number, we will then prepare a certificate for you for continuing education units, along with a copy of an outline of the presentation that you can use for your files should you be audited in the future. This is also qualified for continuing education for CCPSs, and this is a self-reporting system where you go to the NICCP, select My Account, and then enter the email address and password. Once you're in, select Reporting Continuing Education, fill out the requested information, and the organization providing this continuing education is the NCAG. During today's presentation, I'll be giving the answers to 4 questions, and this is for the Certified College Advocate Certificate. For those that are going to be taking continuing education on this in the future, they can write down these answers and then go on the NCAG website to do continuing education recording. Again, the test is not available right now. It will be here within the next month or so. We have a national conference, as I mentioned previously, in Los Angeles on the 4th and 5th. We have a very good lineup of speakers coming, and we're going to be getting that out in the next week or so. But we have some very interesting presenters. It's going to be a 2-day session, August 4th and 5th, with college visits on the 6th. And we've selected a hotel close to the airport that will have free shuttle back and forth from LAX. Again, this will be on a Tuesday, Wednesday, with college visits on a Thursday. Our next webinar is on March 31st with Paula Bishop on educational tax benefits. And again, that'll be at 12 noon Eastern Standard Time. So that being said, we sent you a copy of the slides. I'll send you an updated information on how to report continuing education to correct my error this morning. We'll take questions as the presentation goes on, so type them in immediately, and we'll get to them towards the end of the session. And again, of course, this webinar will be recorded and will be up on our website within 24 hours. So Joe, I've covered all the housekeeping items. I'm going to pass it over to you so you can get started.
Okay, thank you, Gary. I'm going to work off of this screen. I seem to have problems going back and forth from the slideshow screen to this screen. So we'll just use this. This is our title, Trusts and College Financial Aid. We're really trying to introduce a couple of different trusts and whether they're reportable or not reportable on the FAFSA and profile form, and how to do that, how to report that on those forms, what value to use, and so forth. But we'll continue on. We'll go through a little bit of an introduction. At first, different parties of a trust. The first party of a trust would be the grantor and/or donor, whichever you want to use. And really, that's the person who establishes the trust. Grantor is going to determine that he wants one or doesn't want one. Hopefully, you'll be able to advise him on this factor. But he's the one who decides that he wants to set up a trust, however he wants to do it, whatever he wishes to do, and then he's going to produce a trustee for that trust. That would be an individual who's going to handle the trust and who's going to follow the articles of the trust to disperse the income, the assets, or whatever is in that trust as to the wishes of the grantor and the articles of the trust. The beneficiary of the trust is going to be the person or persons, entity, it could be a college, a university, or a research institute. It's going to be anybody who is the beneficiary or who that trust is set up to help or to, give the money to or the assets to. The trust property is going to be what the grantor decides he wants to place into that trust. It could be cash, it could be bonds, it could be securities, it could be a house, it could be buildings, it could be all kinds of different assets that the grantor would want to place in that trust for whatever purposes he may decide he wants to use on that. Common types of trusts, again, a trust in and of itself, there are very few limits on what kind of trust you can set up. You can basically set up for whatever that grantor decides he wanted to do. He wants to set up a trust for education. He wants to set up a trust for a child who has problems, physical problems. He wants to set up a trust for his university, or he wants to set up a trust for the church he goes to. He wants to maybe receive income from that asset while he's alive, and when he deceases, the asset goes to the church, the university, his child, anyone he wishes to name as the beneficiary. The basic types are revocable and irrevocable. We'll go through them. They're kind of self-explanatory to a certain extent. He can revoke a revocable trust. He cannot revoke an irrevocable trust. That would be the grantor. Testamentary trusts would basically, when a person deceases, in their will, this is the old A-B trust that used to set up into a will when the estate exclusion was lower than it is now, and it didn't include both the husband and the wife as a deduction, but only included one, and you needed the A-B trust to save the $5 million for the husband so the wife could use it when she deceases and the whole estate passes on $10 million. You don't have to do that anymore, but still, testamentary trust is still available for many other purposes, and it's written into the will, and it's created at the time that the person deceases. And it's an article in the will that creates that testamentary trust. A revocable living trust would be an inter vivos, or during life. This was very popular a while ago, but it's created while the grantor is alive, and he can revoke or change the articles of this trust at any time he wants to. At his discretion, he can put more assets in, he can take them out. He could say, Sally is my beneficiary. She didn't send me a birthday present this year. She's out. John is in. You can do anything you want to with the revocable living trust. The support trust, again, would be to provide the needs of the children. The trustee is given the discretion to determine the need of the beneficiary. A lot of times it could be a child who again, has a limited capacity, either mentally or physically, and the parent, grandparent, or any person who wishes to set this up is setting it up for their benefit. The trustee is going to pay their bills for them while they're alive to ensure that they have enough money to live, pay their rent, buy their food, buy their clothes. It's usually written with those particular items in it so that trustee knows he's supposed to pay for all of these. And there's usually a little caveat in there saying if there's any other items that deemed necessary for the comfort and support of that person, the trustee has the right to pay for it. The beneficial trust is really something that's set up for the benefit of a minor. A lot of times you hear this, there was an accident, the mother and the child were in the car, the child was injured, they sue the driver of the other car, the insurance company pays the child $150,000, the child is 5 years old. This money is put into a trust. The parent may be the trustee of this trust. If the judge deems that the parent is not capable of doing this, he may appoint someone else to be the trustee. It could be a bank, it could be a financial institution, it could be an attorney, it could be an accountant. There are many people who could be appointed as trustees. We used to handle several of these trusts for a couple of people for their kids. Parent having had a accident and was killed, and a lot of different trusts were set up. Creation of a trust. Again, the trust itself is going to do the purgatory language, which is basically setting forth the grantor's wishes. Whatever the grantor wishes to do, he can do. Also, what do we do here? Okay, get to that later. But we can do that. The grantor, whatever he wishes to do, he can set up the trust to follow his wishes. He can set up a gift, for just an example, a gift for $100,000 for my grandchild, or a gift of $100,000 to be used for educational expenses. Just, you know, he has the option of doing whatever he wishes to do. He may say $100,000 used for my grandchild. I do not wish any of this money to be paid for his educational expenses. That would be highly unusual. Could be done. Basically, a trust, most states in the United States ban a trust written for perpetuity. The DuPonts did this many years ago, and because of that, many states said your trust can follow 2 generations past the present generation, and after that, it has to be, you know, disseminated among the beneficiaries. You cannot set that any further than that, or you cannot set the trust into perpetuity to carry on from generation to generation to generation. There's benefit of doing that. The money stays in the family. You have all kinds of benefits of making that work, so you keep the money inside the family, keep the power within the family. The grantor, of course, has to be of sound mind and have intent. He'll have to want to do something with his money or with his assets. And the beneficiary should not be the sole trustee and the sole beneficiary, because then you're setting up a trust where you're setting it up, you handle the assets, and also you get the assets when the trust is over. You may set it up for, let's say, a period of 20 years. I'm going to put, you know, $2 million into my trust. I'm going to handle how it's invested, and in 20 years, all the proceeds of that trust are coming back to me to handle some kind of maybe legal situation that I want to get away with. You can't really do that. In order for the trust to work, the delivery of property has to be sent to the trust. So the trust has to be delivered the actual property. If the trust is not delivered the property, it ceases to exist. It has no purpose. It has no funding. So it really is just a piece of paper that no longer has any meaning to it. So if you have people who are writing trusts, who you're going to write trusts for, have to follow them and make sure that they do transfer the property into the trust. This happens a lot with this with the revocable living will trust. People write this. It sounds like a great idea to them, and then they never put any assets in it, and the trust dies. They may do that on purpose. It's, you know, up to your client, but you should try to get the property delivered into the trust if you can. A revocable and irrevocable. The revocable trust, the grantor, person who sets it up, can break the trust at any time. They can either say, it ceased to exist, give me all my money back. The beneficiaries have no rights of ownership into this kind of a trust. Have to read the documents. Sometimes it says at the top, John Smith Revocable Trust, John Smith Irrevocable Trust. But a lot of times, even when it says that, you still have to read the documents and make sure it is revocable. Make sure that grantor still maintains rights of ownership. And as long as he maintains rights of ownership, even though your student may be named as the beneficiary of this trust, he has the right to change that. Your beneficiary has nothing to report. They have no rights of ownership on this trust. So there's nothing to report on either a FAFSA form or profile form. The value of this trust for that person is 0. An irrevocable trust, again, the grantor cannot break this trust. The documents and articles are set, and the beneficiaries of this trust have rights of ownership. So this kind of trust, the irrevocable trust, it could have been a testamentary trust, the grandparent died, The trust was set up for the benefit of the grandchild. It's irrevocable. It can't be changed. That child has rights of ownership in that trust. It's reportable. Go on to the next slide. Testamentary trust, again, it's created
Excuse
at
me,
the
Joe.
time. Yep.
I'm going to give the answer to question number 1. The answer is support trust. Again, the answer to question number 1 is support trust. Thanks, Joe.
Okay. Testamentary trust, again, is set up at the time the person deceases. It's written into their will what they wish to do. This is a revocable trust. The grantor, as long as they're alive, they wrote the will. And as everybody knows, you can change your will anytime you wish to. So you can go in and change this trust if you wish to. So it's revocable. You have to take a look at it. And if anybody tells you they set up a trust inside their will, you want to take a look at it, realizing that it's most likely revocable because I can change the will. If the student is named as a beneficiary of this trust inside the will, it's still a revocable document. So the student has no ownership in that, contingent upon the death of the grantor. As soon as the grantor deceases, that will becomes in effect, and that student is now has ownership in the trust, ownership in the will, whatever. But also, it's a matter of the will is written, but the will has to be probated. And if you're filling out a form, a FAFSA form or a profile form, and let's say the grandparent deceased, but the will is not probated, that will is not final now, it is not permanent, the court has not said it recognizes it, it can still be challenged, so it's in doubt. So the student in that situation has no rights of ownership yet until that will is probated. So if you run into that situation, kind of take a look at it, may be able to say the will hasn't been probated, the student has no rights of ownership, we don't know what it is, it could be challenged, the student could be dismissed as a beneficiary, the will could be thrown out, and everything is in probate, and the student gets nothing. We don't know yet. The court has not probated that will. Revocable trust, set up to avoid probate. A lot of times, the revocable trust is set up because you have a trust document, does not have to be probated. And it's set up to protect property. You're giving an extra layer of protection to a person. They get sued by somebody, they're sued. Now the person has to go and sue the trust in order to get some document because the ownership of the assets is within the trust, not in the name of the person. Property is deeded to the trust and ownership transfers to the trust. That's what we're talking. People have to sue both parties in order to get that. The beneficiaries have no rights of ownership. It's revocable. It can be changed. The grantor can go in there, change the trust, change the beneficiary, change whatever they want. The revocable trust becomes irrevocable upon the death of the grantor. As soon as the grantor deceases, that trust now becomes irrevocable. The student, not like in the testamentary trust, the student in this trust, the revocable trust immediately becomes irrevocable, and they immediately gain rights of ownership. No probate is necessary on this. As long as the grantor is alive, it is not a reportable asset to the student. Once the grantor deceases, the student then has the rights of ownership, and it is reportable at that time. The irrevocable trust document cannot be altered. Beneficiaries are set. Disbursements are at the discretion of trustees or written in the articles. This trust is reportable on a profile and FAFSA form. Again, it's important, even though it says irrevocable trust at the top or in the name of the trust, it's important to read the document and make sure that grantor hasn't maintained some rights of ownership. If they maintain some rights of ownership, it's now revocable, doesn't have to be reported. As long as they do not maintain any rights of ownership and the student has rights of ownership, that value of that trust is reported on the profile and the FAFSA. We'll go to the one thing we were asked before. What's reportable is the value of the assets at the time you fill out the form. If you have a student who is getting income from the trust. They're getting $20,000 a year for the next 6 years, or while they're in college, whoever they wish. It might be $20,000 a year, or their tuition, their educational tuition paid for the next 6 years, or till the time they graduate, whichever comes first. Now, what you report is a present value of that stream of income. You have to look at the document. It could be 4 years, could be 6 years. Now you have, you have a difference in here of how long is the education going to be. But you're going to put in the present value of that income stream. If you have a trust that's writing, and it's written, we're paying the educational expenses of this student when the day they graduate, they get all of the assets of the trust transferred to them, or let's say when they're 30 years old, they get all the assets of the trust transferred to them. You're supposed to report the value of those assets the time you fill out the form. Now, they're going to get an income stream from those assets every year. And if you now go and you report the value of the assets and you report the present value of the income stream, you're reporting that twice. I would report one or the other, depending upon how that document is written. If they're going to receive the assets in 30 years or something like that, you may want to just put in the present value of that assets. The income stream that they get on a FAFSA form is going to be reported on other income and reported in there. If they get $20,000 this year, next year on that other income, it's going to be $20,000. So you want to make sure you're not double reporting some of these assets and some of these income streams. Be particular with how you're writing this up and how you're reporting it. The support trust, again, it's provide the needs of a minor or incompetence. This is basically a lot of times set up by a grandparent or a parent of the student. Again, I have several of these where the person is incompetent. I have one or two where the person actually has a job, but they're really not capable of handling their everyday expenses. They have a trustee appointed to them with assets put in that trust to help pay for their living expenses. And some days it may be $500 one month and $1,000 another month, depending upon their needs. And it's the trustee's discretion to determine what they need. If they give them a bill for $1,000 for clothing, and then the next month they give them a bill for $3,000 because he wanted to buy his girlfriend a fur coat, I don't know that the trustee would allow that. But these are things that are in the trust documents and up to the trustees, and that's how the trustee is given great discretion in some of these items. But he's also has to fill out a 1041 at the end of the year telling people how he dispersed the money. Generally, the grant with the parent, grandparent, the trust is irrevocable and it's reportable. The support trust, the income goes in there, it stays in there, and it's irrevocable for the life of that person who is the beneficiary. You could have other types of articles. You could have a person write a support trust saying that we have $100,000 in there for the support of John. His brother Sam is going to be the trustee of these assets. I am the grantor of the estate, and I placed $100,000 in there. But I put in a caveat which says, should I run into trouble, should I need money to pay for my living, my food, something else, should something befall me that makes this something that I need this money to, the trustee can then give me back the assets or write a check for my support. These are different things that now all of a sudden this irrevocable trust becomes a questionable, is it irrevocable or is it revocable? I put it in a caveat where I can make a change in there depending upon my situation. So in here, it's arguable whether it's irrevocable or revocable. You may want to say this is a revocable trust and it's not reportable. But as such, if you have, a minor incompetent, could very easily be attending college, and that's something that trust in itself, for the most part, will be irrevocable, and those assets will be reportable. And they'll basically be for, most likely, for the expenses of the child, which are going to cover food, shelter, clothing. And you want to make sure that the financial aid office knows what that's supposed to cover, that that's really not supposed to cover education, because maybe when it was written, they weren't really contemplating the student attending college, so they didn't put that in. And therefore, really, and there might be only enough money to cover the living expenses of the child. So you may want to make them fully aware of that, where they could actually perhaps get some money from the school, because the school's going to say, well, we're going to take the trust and cover their dormitory fees, their meal plan, and things like this, but their tuition may not be covered by this, and so therefore they have to rethink that. And they have great discretion on doing that. And it's up to us to make sure they understand what this thing is doing and is supposed to be. The beneficial trust, that's created by the court. It's much similar to a support trust, created by the court, where something accident has occurred, where the minor child has had injuries, and they were awarded by the insurance company X amount of dollars. Now, it could be they're awarded $500,000 to pay for their medical expenses, for their living expenses, their food, their shelter, all of this stuff. And there could be something written in there that educational expenses can also be covered. You have to look at this carefully. You have to see what's happening. It could be, allowing the funds to be used for educational expenses, but now you have a student or you have a child who has great medical expenses. Maybe they need physical therapy every day for the rest of their life, or they have items that they need. They have to be monitored. They have to be, all kinds of different things can be occurring that are expensive, and they have special insurance to cover for this, but most of the expenses that's in this trust are going to take care of these medical needs. These medical needs, I would make sure the school knows that these are primary to their tuition, and that if money is taken out of this trust to pay for tuition, they will not be left with enough money to pay for their medical needs, which will become a burden on society and perhaps even on the school. So you want to make sure, read the documents, make sure you understand what's happening, make sure you understand the assets, make sure you understand the peculiarities of the individual, and let the school know, oh, because they're not going to know unless we tell them. Reportable trusts. Basically, any trust that's irrevocable. Yep. Gary, was that you?
I'm sorry, hang on.
Okay.
Bear with me a second, folks. The answer to question number 2 is trustee. Again, the answer to question number 2 is trustee. Thank you. Okay, Joe.
Thank you. Okay, so we'll go to, different reportable trusts. We've gone through several of these different things. There are lots of different kinds of trusts that will be reportable. But this is mostly what we're taking a look at. Any trust that's irrevocable is reportable. The student has ownership in the trust. When the student has ownership, it becomes reportable. If the trust states that the money isn't available until the student is 30 years of age, according to the rules, it's still reportable. Even though, your parent may say, well, he's not going to receive any income until he's 30 years of age, but it says in the forms that the trust has to still be reported as an asset of the student. So it's 30 years old, still have to report the value of those assets at the time that form is signed. Now again, this is something for judgment of the financial aid office, and you have to let them know what it is. I would actually make a copy of the trust. You're going to want copies from these people of the trust document so you can see what it is. A lot of it is, a bunch of legalese, if we to not use another term. But it's a lot of legalese in there, but you're going to get to the educational documents, the support documents, so you're going to get to the essence of the trust. And then you can send them a copy of what the essence of this trust is, with kind of like, I would highlight what we want them to see, what we want them to read. I would send them the whole document, but make sure they can easily find what you want them to see. They can read the rest if they want to. We don't want them to think you're not sending them the rest because you're trying to hide something. But send them and highlight what you want them to see so they can see that this student isn't getting any money while they're in their school. They're going to receive it later on. It's now a debatable point whether how they're going to use this. Are they going to still hit it as an asset? Or are they going to use their professional judgment and say, well, we'll lay this off, but maybe they're going to say the student can borrow the money and pay for it when they're 30? Well, not really. The argument is because as soon as they graduate, they have to start making payments. They're still not going to get money till they're 30. They may graduate at 22. That leaves 8 years of payments they have to make, which may be, onerous on them if they're not having this money till the 30. So these are arguments you can make with them, but you want to make sure you see the document, you understand the document, you highlight what you want them to see, and then you can, negotiate with them, and hopefully using their professional judgment, they will go along with you. In the comment box on the profile form, they leave you a place to explain this. I would put an explanation in it telling them what it simply is, and then send them a letter anyway and tell them you're going to send them the documents so they can, using their professional judgment, they can hopefully make amendments to the award letter and give the student a little bit more money, or at least something that's going to be reasonable to them. Trusts that are not reportable, going to be revocable trusts, are not reportable. Whenever the beneficiary can be changed, the report is revocable. It does not have to be reported. Whenever a trust document can be altered, the trust does not have to be reported. Because whenever the grantor can change the beneficiary from one student to another or back and forth, he's maintaining ownership. If he maintains the right to alter the document in any way, he's maintaining ownership. And once he's maintaining ownership, the student has no ownership rights in that trust. It does not have to be reported. So make sure when your parent comes in and say, oh, John has a trust. Well, you have to make sure what kind of a trust it is. It may not be reportable, or it may be reportable, depending upon what they say. And not depending upon what they say, but really depending upon what the trust says. I wouldn't necessarily trust to hear what they're going to tell you what this trust is. You're going to want to look at it and see it and tell them, I really want to see a copy of the trust to determine whether it's not reportable or it is reportable. They're going to tell you it's not reportable for whatever reason they may think. But it may be reportable, and you want that backup information. If you're making a statement that this is not reportable, you want to make sure you have something to back up your opinion. The student has no ownership until a contingent event occurs. In most trusts, it's the death of a grandparent, death of a parent, a certain age, or whatever. I mean, you could actually write a trust saying, John is my beneficiary of this trust when he becomes 30 years old. Before that, Sally is the beneficiary, or my university is the beneficiary of my trust. When my grandson becomes 35 years old, should he need the money, I am going to make him the beneficiary, and I want the university, or the university will receive half of the money at that time, and he'll receive the other half at that time. You're really writing in something that may not be reportable when you're doing something like that. That's kind of like really off the wall. I don't know that a lawyer would really do that, but it can be done. After all, this is supposed to be the wishes of the grantor, not the wishes of the attorney. Whenever a trust can be altered, by the grantor. The beneficiaries do not have ownership. In trusts, there are going to be things written in there that are going to say, I placed, $1 million of assets in trust for my grandchildren, John and Sally, to be given to them when they reach 30 years old. You're going to have an educational clause in there. Any of the trust income could be sent out to them, or it could be sent out to the grandparent's parent. And then while the grandchild is in college, their tuition can be paid out of the corpus of the trust. And in this case, these grandchildren have beneficial rights in that income that's paying for their tuition. Now, you could have something written in there, unless, should I become incompetent, or should I become, physically unable and need to have medical costs paid for me, for a nursing home, for operations, for surgery, for any of these purposes where my assets are not enough to cover my expenses, then the corpus of this trust can be used to cover these expenses of mine, which is the grantor. So basically, you're leaving in there an article that says money can be taken out of this trust to be used for the benefit of the grantor should any of these things befall him. Now, you can look at the, say, how much assets does the grandparent actually have? The grandparent's putting $1 million in there, and let's say the grandparent is retired, and they're collecting Social Security in their retirement, and they have another $500,000 in a savings account for themselves. Well, that could lead to the fact of it can be very easily supported that the assets in that trust may be taken out to the support of this grandparent because they haven't really maintained enough to really reliably say they are never going to need this asset. If you can say they're never going to need this asset, the student absolutely positively has ownership. If you say it's in question, they may not. And this is something that you want to report to them, you want to show to them, you want to explain to them that the grandparent really didn't keep enough money for themselves. Maybe they're 85 years old, never really contemplating they're going to need any of these medical expenses, and they could be wrong. And therefore, the assets in the trust are being put in question. There's a lot of questionable items in here. So, I mean, it's incumbent upon us to bring some of these things up to these financial aid officers to make them understand that the trust assets are not necessarily that. They may change. They may be in repute. They may change. They may become less. They may become more. And it may not be exactly what is shown on there. And we have to explain to them why and why this may be. And hopefully we'll get them to understand that maybe you should not be assessing these assets to the extent that you want to. If the student is the beneficiary of the trust, it's irrevocable, it's reportable. Easy. We have to determine whether it's irrevocable or not. If the trust says your student does not receive anything until they're 30, it's reported. Now we went to this other instance where if they're just getting an income stream, where they're getting $50,000 for 4 years, at the end of the 4 years, their parents get the corpus of the trust, then all they have is this income stream, and you should report the present value of that income stream. Now, if the parents are getting the corpus at the end of the 4 years, maybe you have a reportable asset to the parent as well as an income stream to the student. So these are things that have to be looked at and what's going on and what's happening. College or university does have professional judgment on these items. It is incumbent upon us, again, to explain to them all of the implications on the particular trust. Anybody have any questions on these, we'll have a time. But it can be a very gray area. Send a copy of the pertinent item in the trust with what you want them to see highlighted. That's my main thing. Highlight what you want them to see. You may want to send them the whole trust, just what's pertinent to them. And this should allow you to get the best results for your students. Just go through, we're going to have in a few months a follow-up on just on trusts and the different kinds of trusts, how you can use them to help your clients. We're just going through a trust used to reduce the cost of education. We just set up a trust with the asset of $500,000. We're going to say the education of the student. We're talking about people who no way are they ever going to get financial aid. The education of students, $50,000 for 4 years. Okay, we're going to set up an ILIT, which is an irrevocable life insurance trust, which is set up for the amount of $2 million, and that premium on that ILIT is paid by the trust. And now we're going to make a donation to charity at the end of the period. We're saying is 30 years, so at the end of 30 years, the church, a college, a university, I'm going to give this $392,000 to St. Joseph's College in 2045. Okay, fine. Maybe because of that, we all of a sudden have the Nagy Library at St. Joseph's College. Or maybe they just name a room after me. But whatever, you can do this and get some recognition for that. The benefits and tax savings. We're giving $392,000, 30 years. We're getting a charitable tax deduction for this. We're going to say it's worth $137,000 at a 35% marginal tax rate. But you get that tax deduction not 30 years from now. You get that immediately. So now you're getting them $137,000 tax deduction. They're putting $500,000 in there. Now they're removing $1 million from their estate for estate savings of $400,000 for an estate value over the estate tax exclusion, which is going to become a little bit more difficult now that a married couple can have an estate tax exclusion of $10 million, not just 5 to one, 5 to the other. It's a combined exclusion, $10 million. The ILIT pays the beneficiaries the inheritance they lost. If it's your children and you're worried about them and you say, I want to be beneficial, I want to make this donation to St. Joseph's College for this $392,000, but I also don't wish my children to be denied their inheritance, so the ILIT is going to pay them their inheritance that they lost when I decease. And this is called a charitable remainder trust. And we can go through some of these different things and reasons and how to use them and how you can maybe help people with that. Oops, what happened? Okay. But this is, we can have some area for questions. Gary can give us another couple of things, but this is my contact information. I know this is a little bit shorter than we necessarily wanted, but hopefully we'll have some questions. Oops.
Joe, we do have some questions, but before I start on that, the answer to question number 3 is assets. Again, the question in number 3 is assets. Okay, let's start off with this one here. If a trust is irrevocable and it's for 10 grandchildren of varying ages, how do you value one child's trust? Let's say the trust has a value today of $2 million.
Well, each child, if you're valuing it, you have 10 children, all of different ages, but you're filling out a FAFSA form for John, and you're not worrying about the other 9 children right now because it's just the one child. It's the value of that asset that's having to fill out the form. But their ownership in that asset is 1/10. So it would be $200,000 would be the value of that asset for that child. Because if you were filling out the asset for all 10 at the same time, the value of all 10 put together would be $2 million. You can't say it's $2 million because that's not correct. It's not $2 million for each child. It's 1/10 at any particular time that child is going to need that money. So at the time you're signing that form, it's 1/10 of that asset value, $2 million to $200,000. You may have the next student And when they're coming, that asset may have appreciated in value considerably, and their value may be $300,000. But we don't know that now. So all we can do now is for the one child, or however many child there is, and for each one of those child, it's 1/10 of the total value of the trust, which is $200,000. Okay?
Okay. I'm sorry, Joe, we're getting a little background noise there. So let me go on to the question here. We've got, let's see, medical trust. Students going to college in the fall of 2015 has cerebral palsy. Trust was set up for medical, not college. Turns out that he can go to college, though, but he's still going to have tremendous health care expenses throughout life. How to advise the college that that it's to be used for medical and not for college? Is a
Yeah, I mean,
professional override by the financial officer the only way to do it?
really, I mean, you can't, it's pretty straightforward. Do you have a trust? Yes, we have a trust. What's the value? This is the value. Now it's incumbent upon us to let them know what's going on, especially for medical needs like this. I was trying to allude to some of them. But cerebral palsy is definitely a need that is going to have, extreme medical costs. And we don't know the cost of it right now because cerebral palsy, as it progresses, the medical cost becomes more and more as the student goes through. And if educational expenses are not mentioned in that trust, you have to say, this is the trust for medical benefits alone, and it's to be used for their medical benefits. Now, can you say if it's being used for medical benefits, it's not being used for educational benefits, we can just exclude this? That I don't, technically not really. You have to put it in and you have to explain to them what it is so they can take that money out of assets and not assess that money. You have to really get a copy of the trust, send it to them, show where it is, and then really in an explanatory with a letter from the doctor would be fantastic, saying that medical expenses for this child are unknown and they're just going to be increasing exponentially in the future. So all of this money is going to be used for this child to take care of their medical expenses. That's the best thing that I could say to take care of that situation.
Okay, Joe. Next question. If the parent is the grantor of an irrevocable trust, do they have to report it? And if they do they report it as a parental asset?
If the parent is the grantor
of an irrevocable trust.
Well, it depends upon who the beneficiary is. Okay. But if let's say the beneficiary is not the student, so the student has no ownership. Let's say the parent set up a trust for the benefit of St. John's Medical Hospital. Okay, the medical hospital is the beneficiary of that trust. That parent is the grantor of the trust. They put the $1 million into that trust. It's for the benefit of St. John's Hospital. That, even though it's an irrevocable trust, the parent, the grantor, has no ownership in that trust any longer. It is no longer their asset. The child has no ownership in that trust. It's no longer their asset. That particular trust is not reportable on any of the forms. Okay?
Okay. Next question. Referencing non-reportable trust. If the trust is irrevocable and the trustee has the power to sprinkle and spray, is that a non-reportable?
The trustee has the right to sprinkle and spray money wherever they wish to?
Yes.
It's irrevocable, right?
Correct.
The student is the beneficiary. If the student is the beneficiary, if it's irrevocable, the trustee really doesn't have the right to give anybody he wants to the money. Generally speaking, it's written in the articles. But
okay.
If it should be that the trustee is given the right to, because there could be a charitable trust where the trustee is given the right to give and sprinkle and spray any amounts they wish to any charity they wish to, and then it's not reportable because the student is not necessarily beneficiary. only to the amount that the trustee wishes to give to the student. So if the student does not specifically name the beneficiary there, and he's given the right to give money to anybody he wishes to or any charity he wishes to, then it's kind of unusual. Usually they specify to any charity that you wish so to get the charitable deduction, but it may also be determined that he may give the money to any child. If it's named any child, then you got a problem. But if that's not, if the trustee is just given the right to donate that money to where he feels it's a benefit, then no.
Okay. Another question, irrevocable trust. Irrevocable trust, but the trustee has the ability to remove the student as a beneficiary. Does it still have to be reported?
It's not irrevocable then.
Okay.
It's a revocable trust as soon as that grantor remains rights of ownership, and by maintaining the right to change the beneficiary, he's maintaining the right of ownership, and therefore it's not a student asset. It's not reported to the student. It is the asset of the grantor, and if the grantor is the parent, it could be reported to him. But if the grandparent, no, it's not reported to anybody, and it's not on the form.
Okay. Other question, have you seen reportable trust affect the amount of a merit-based scholarship on a college willing to offer it? In other words, are these trusts impacting merit-based scholarships?
They shouldn't be. I haven't seen them, impact a merit-based scholarship, typically because the merit-based scholarships are awarded prior to financial aid, and they should not have any bearing on the fact. As a matter of fact, if you have a big trust, they might even increase the merit-based award. But I technically and ethically, it should not affect a merit-based award. But we all know that typically the more wealthy a parent is, the more likelihood they're going to get a merit-based award. And that could be simply because the students are better, but typically most merit-based awards go to parents who are not going to qualify for financial aid. But I have not seen these things affect merit-based awards.
Okay. Next question, what has been your experience in explaining the value of an irrevocable trust as a special circumstance?
That's hard.
Okay.
It's really hard because you have people who do not understand them. So it can literally take a meeting with them to explain it to them and to show them by writing the letter and by showing them the trust document. And if the letter is specific enough and they can see it, and if you can if you can explain it enough so they can actually see what's going on, if you can make a spreadsheet on expenses and so forth and show how the income of the asset is going elsewhere to help other things, it makes it easier. But you're talking to people who are not versed in this. They do not have financial background, so it's hard. It's been done, and my experience is the better the student is, the easier it is to explain to them.
Okay. Next question is here. Let's see. Bear with me a sec. Oh, an ILIT, reportable. Is it, since there's life insurance inside the ILIT, is it reported as a trust, or isn't it reported because of the life insurance?
The irrevocable life insurance trust is a separate trust. Mm-hmm. It's not inside of the trust. It's a separate trust. Your trust is simply paying the premiums on that trust. It's a trust really to benefit to either an ILIT is written to either pay the estate tax or to reimburse the grantor's beneficiaries for the money that they would lose, and it's separated from there. And the beneficiary of the grantor is going to be the beneficiaries of the ILIT. And and like any other life insurance, its value at any time is only its cash value, its cash out value, but it's not part of that trust. The trust documents itself are going to warrant what the value is. Now, if you're going to be paying the premium for the ILIT, you may be reducing that value by the premium of the ILIT. Because if the ILIT is the irrevocable life insurance trust is being paid over a 30-year period of time, it's quite conceivable for you to determine present value of those payments and to reduce the trust value by those payments. That would be, I would say, that would be the thing, how to handle that. But it's a separate trust, and the value of that trust does not go into the reporting of the other trust. Okay?
Okay. Next question. Have you ever seen a college ask for a trust document?
No.
Okay.
They don't ask for them. No, I'm trying to, wait a second. No, I have seen that, yes. My answer is yes. I have seen that. I have had them a couple of times ask for a trust document. I've also had them ask for divorce documents. So sometimes they do ask for them. Trust documents, I'm sorry. I have had that a few times. And then, I send them, the document, and I kind of highlight what I know they're looking for to help them out.
Next question is, with a testamentary trust and minor students, can the students spend the money down in the trust prior to college years?
So a testamentary trust is a trust that's inside the will of, let's say, a grandparent or a parent, and the grandparent or parent deceases, and $100,000 is put into a trust for the child. Now, it's basically, because I'm going to assume that this is a minor before they're going to college. It doesn't necessarily have to be that, but let's say it's a minor, and before they're going to college, can they spend it down? Sure, they can. It's supposed to be used for their expenses, and whatever the trustee is going to deem to be their expenses, they can use it for. They can use it to pay, I would assume, to pay the costs of courses, to take exams, to buy a car, to buy a computer, to buy all these kind of necessary things for them for their education or for their upkeep. Maybe paying rent in the house, or maybe paying real estate taxes, because he's spent down for lots of different reasons.
Okay, our last question is going to be an interesting one. It's on 529s and trust. But before that, I'm going to give you the answer to question number 4. The answer to question number 4 is income. Again, the answer to question number 4 is income. Our last question today. How would you treat a 529 account held in a trust for the benefit of the student? Is it a parent asset, as a normal 529 would be, or is it a student's asset because it's inside the trust?
Well, the 529 plan written for the student, which can be changed, so it's parental assets.
Mm-hmm.
But inside the trust, now it would depend upon what the grantor is doing or did with the trust. If the grantor put the 529 plan inside the trust and the beneficiary of the trust is the student, then the student, if that trust is now irrevocable, it's the student's asset, because the only way you can use that 529 plan is for the student. Because the student is the beneficiary, you can't change it.
Okay.
If the grantor maintains the right to change it, to change the beneficiary of the 529 plan, even though it's inside of the trust, if he maintains any rights of ownership, then it's not the asset of the student, it's the asset of the parent.
Okay. And just part 2 on that, what about if the trust was a testamentary trust? Would that have any difference?
Well, yeah, because in the testamentary trust, the grantor is deceased, and they're not going to be able to change that designation. So the 529 plan, is there if the beneficiary is the student, and it's the asset of the student. And I would think that would be whether the 529 plan was, well, no, because the contingent beneficiary would have the right to change the beneficiary on the generally 529 plan. But in a testamentary trust, if that 529 plan is there, you can't change it. That's it.
Good. Well, Joe, that was our last question, and perfect timing. It's just a few minutes after 1 o'clock, so I'd like to thank everyone for joining us. It was a pleasure putting you on the spot with all these questions, Joe. I really enjoyed it this time. For those of you who are going to join us on our next webinar, it's going to be on March 31st. Paula Bishop from Seattle is going to be doing a presentation on education tax benefits. And Paula always puts together a good presentation, so I'm looking forward to that. Everyone who joined us today, thank you for taking the time for this, and thank you for your continued support.
Can I make one more comment, Gary?
You sure can. Go ahead, Joe.
On a trust, make sure you get a really good trust attorney when you're advising people on the different kinds of trusts that, unless the trust is already written, if you're going to write something up or something like that, you need a really good trust attorney to do that. That's about it. This can be dangerous. Don't try to do it at home on your own.
Okay. Joe, thank you very much. Everyone, have a good day. Goodbye now.